Good morning, everyone. We are just letting lots of people in and we will get started in a minute or two. We're just going to make sure everyone's got the opportunity to get in. We're going to be recording, so if you're on witness protection or something like that, log out now. But otherwise, we'll be recording, so we'll circulate it. So if any of your colleagues haven't been able to make it, you can send that on to them. We have had an excellent response to this, which shows how big an impact it's going to have on us all. I'm going to share my screen with the slides on. And I think I'll just make a start if that's okay. Thank you everyone for joining us. There is well over 140 of us, and the number keeps ticking up, which I do think shows how big an impact this case is going to have on the work that we do. And we are here to try and provide some clarity. Spoiler alert, we don't have all of the clarity because I think there's some unknowns left still to be explored. So we're here to talk about the big case of the Supreme Court last week, which is, I think, commonly being known as Agni. It's a reference by the Attorney General for Northern Ireland, and it was in the Supreme Court. I am Eilish. I'm team leader of our Court Protection Health and Welfare Department. I am joined by Sarah Jackson, who's a director in this department, Sarah Lynn, who is a senior associate over in our Penrith office, and Nicola, who is a senior associate in our Manchester office. We're going to share some of the presentation. We are planning to talk for about 40-45 minutes and then leave plenty of time for questions. There is a Q&A box, so if you can pop your questions in there, that would be fabulous. We're going to work through what the law has been, where that comes from, how we got to a point where the Supreme Court was reviewing that. Sarah Lynn's going to address the new test for Adele, and Sarah is going to talk about human rights case law and kind of what we need to know about that to apply that new test. We're going to look at what safeguards are still in place, because I think that's a big concern for people, what we don't know and areas for consideration that might be tested, and then we'll run through some questions. So I am going to start with a whistle-stop tour of where the law comes from and what the law has been. And so the reason we have any system in terms of authorization of a deprivation of liberty is because of Article 5 of the European Convention on Human Rights. Article 5 says that everyone's got the right to liberty. It says that no one shall be deprived of that liberty except in the following cases, in accordance with the procedure prescribed by law. So our procedures prescribed by law obviously come from criminal law, they come from the Mental Health Act, they come from the Deprivation of Liberty safeguards, which form part of the Mental Capacity Act. The relevant subsection for us is 5.1e, which talks about persons of unsound mind, which is a term that I hate, but it's there. And so where someone lacks capacity or they've got mental health problems, how is that authorised? 5.4 provides that where someone is subject to a deprivation of liberty, they need to have access to a court, or in mental health cases, a tribunal, so that a court can decide whether that is lawful. And so we're here today talking about the umbrella of the Court of Protection, which is what it is said makes us compliant with the convention. And then just lastly, where someone is unlawfully deprived of their liberty, they've got the right to compensation. Worth bearing in mind as we move into this new era. What has the law been? If at any point I go on mute by accident, please tell me. What has the law been? So the law since 2014 comes from the case of Cheshire West, which was a Supreme Court decision in itself, And really, I'm just talking about this so I can wheel out my slide, which I won't be able to use anymore. And just to say that this is no longer applicable as of last Tuesday. There's no implementation period. There's no time for us all to get our heads around it and all of that before the law changes. So just to give a really quick recap, this was the defining case. It set out 3 limbs of a deprivation of liberty: the objective test, the subjective test, and imputability to the state. The objective test, what is a deprivation of liberty, was known as the acid test, and that was in itself 2-limbed, which is the person subject to continuous supervision and control, and also not free to leave. Now, continuous supervision and control has always been a relatively nuanced point. Doesn't have to mean 24-hour care. It can mean someone, you know, has a bit of time out on their own, but they're brought back to their placement by some means of some mechanism in their care plan, let's say. The subjective test is whether they've got capacity to consent to that. It has been the case that if you lack capacity to consent to those arrangements, someone's got their hand up. Richard, I'm going to just ask you, they've taken it down. I wondered whether I just wasn't being heard. I'm going to keep talking. Where someone lacks capacity to consent to their arrangements, authorization has been required. So either the DOLS framework or the Court of Protection has needed to stand in that person's shoes to authorize it. Otherwise, it was an unlawful detention. That's changed, and Sarah Lynn will talk about that. In order for that authorization to be required, the deprivation of liberty has been required to be imputable to the state. So in some way responsible, the responsibility of the state, be that because the NHS or local authority are funding their care or arranging their care, or just that they know about it where it's a completely private arrangement. Famous quote from Lady Hale, as she was then, the fact that living arrangements are comfortable and indeed make life as enjoyable as possible should make no difference. She said a gilded cage is still a cage. And that has been quoted many, many times. It turns out now that a gilded cage might not be a cage, depending on a number of different factors that we'll talk through. So I am going to hand over to Nicola, who's going to talk a little bit about how we got where we are now.
Morning, everybody. So I thought it would be helpful just to take a quick look back to see how this case actually arose in the first place before we go on to look at the Supreme Court's judgment, just to give a little bit of context to our discussions. So actually, it was a reference by the Attorney General of Northern Ireland, and it came about because they were looking to amend their DOLS Code of Practice and wanted to provide for P to be able to give valid consent to a deprivation of liberty, even where they lacked capacity to make decisions about their care and treatment. And so they asked the Supreme Court whether the new Code of Practice was compatible with Article 5 of the European Convention of Human Rights, which, as Eilish said, is the right to physical liberty. So the Supreme Court was presented with numerous arguments over the 2 or 3 days in October last year. They looked at European case law, and I'm not going to say too much about this because Sarah will be speaking to you about it in a short while. But 2 of the important cases which were considered were the case of Stork, which is a German case from 2005, which looked at both an objective and a subject element to a person's deprivation of liberty. And then there was an Italian case of Gazzardi from 1981, which said that a multifactorial approach should be taken when looking at whether somebody is deprived of their liberty or not. And there was obviously lots of argument heard about the Cheshire West decision back in 2014, which resulted in the acid test, which we've all become so familiar with. So if we can just go on to the next slide to look at the parties' positions. So the Attorney General's argument was that where P lacks capacity to make decisions about a deprivation of liberty, they might still be able to give valid consent by expressing positive views and wishes and feelings rather than just passively not trying to leave. Interestingly, the Attorney General wasn't actually asking for the Cheshire West acid test to be changed as such, but pointed out that it didn't object the subjective element, which was found in other European case law. The Lord Advocate of Scotland, who's the most senior law officer in Scotland, broadly supported the Northern Irish position, but said that it should be subject to safeguards as to how P's consent is obtained. And our own Secretary of State for Health and Social Care intervened in the case and said that it should be widened, and was the one who actually said that the acid test should be set aside. The Secretary of State highlighted that the implication of Cheshire West was that it resulted in people who are happy with their situation, who aren't expressing a desire to leave, actually having their deprivation of liberty authorised, and that this was an unnecessary intrusion in people's lives because of the number of assessments that they have to be subject to, the number of professional visits and so on. And there were 3 charities who also joined in the case, the National Autistic Society, Mind and MEMCAP, and they highlighted that people without decision-making capacity cannot give valid consent. They were really concerned that there should still be periodic independent reviews for people who are kept in restrictive settings, and said there's no need to relook at the Cheshire West acid test. There's no justification for that being re-examined. We've all been very used to how the implementation of Cheshire West over the last 12 years, and the charities were concerned that to change things now would just add confusion, and that really this should be something which was dealt with through Parliament with an open and transparent consultation process. And the official solicitor also supported the Cheshire West acid test and said that the concept of valid consent shouldn't be expanded to people who lack capacity. Thank you.
Thanks. So, as you all know, the Supreme Court did not agree with the official solicitor and the charity interveners in the case, and instead has given us a completely new test, which again is still framed quite similarly in terms of the objective test and then a subjective test. So the formula is not dissimilar and at least vaguely familiar to us all. But they said that the constant supervision and control and not free to leave is too simplistic, and it's not capturing the nuances of a deprivation of liberty. Instead, what the court said is that there is fundamentally a multifactorial test, so which is a very wordy way of saying we're going to have to look at it on a case-by-case basis, taking a lot of different factors into consideration, including the type, duration, effect, and manner of the implementation of the measures in question. So we're back to having to go through all of the care plans and all of the evidence in quite a lot of detail to determine whether there is, in fact, a deprivation of liberty. There's a number of possible factors that are flagged throughout the judgment as they go through the various different cases. What the court has not given us is a list. They've not said these are the only factors and these are factors that are not relevant. So it's still going to require quite a lot of detailed consideration for each case. But the degree and supervision of control over the person's movements is a relevant factor, which makes sense. That's similar to the constant supervision and control, looking at how much supervision and control there is individually. The possibility for them to leave the restricted area, again, that's similar to the not free to leave, but slightly different. The extent of isolation is also a relevant factor, and this comes from the fact that throughout the judgment, the court was comparing to being in a prison cell, because they thought that is the epitome of what a deprivation of liberty is being in a prison cell. So the closer it is to being in a prison cell, the more likely it's going to be deprivation of liberty, which is why the extent of isolation is there. So if they are on their own a lot, If they're not able to kind of interact with their peers, with their family, with their friends, then that's more likely to be deprivation of liberty, again with the availability of social contacts as well. The effect of the restrictions on the individual. So if it's causing significant distress to them, if it's having an impact on their mental health, again, that's familiar to us because that was a question on the DOLS forms about the impact the restriction is having on the individual. The duration of the restriction, again, not dissimilar. We have had the period of time being relevant to the deprivation of liberty test for some time now. The relative normality of the placement is kind of a bit of an interesting curveball they've thrown us, and that does seem to be slightly different from the gilded cage scenario, because this isn't necessarily about whether we think it's right for the person, but about whether it's relatively normal for that person. We think, but as we'll discover later on in the talk, there's still a lot of things still to be determined and decided upon. And as I said there, the purpose of the restriction and how far removed it is from the idea of a prison cell. And then we have the subjective test, if we can. Yeah. So the subjective test has changed significantly, and this is obviously the bit that the Attorney General was most interested in. And what the court is now saying is that the presence or absence of objection is relevant. So if they are happy and they're content and that they seem to be going along with everything, that is a relevant part of the test. We have some useful quotes there. So looking here at the stress for the individual in having their objections overruled might lead to suffering and a result in the use of physical force or restraint. So if they're getting upset, they're trying to leave, that's going to increase the restrictions. But also if the arrangements for an individual's care and treatment accord with their known wishes and feelings and they are happy with them, it may be difficult to conclude that they are subject to a deprivation of liberty because there's unlikely to be any element of coercion present in that situation. So essentially what they're saying is back to the world that we used to live in, where if they're not objecting, it may not be a deprivation of liberty, but it's still not, definitely won't be. The judgment also makes it clear that consent in terms of capacitated consent is not required. They've decided that in this context, consent means something different, and it's a much lower test based on the person having some conscious awareness of their situation and accepting that situation. So slightly different to capacitated consent because they don't have capacity to consent. What it says is that compliance or acquiescence will carry less weight, particularly if there's medication involved that might be a factor. So if they're on sedating medication, that is likely to indicate that there isn't. Slides have just changed. And then it may be that if nothing more than mere compliance or acquiescence is a feature of the case, that is enough. That is not enough. So the court does seem to be saying that there needs to be something more than just sitting there and acquiescing to what's going on around you. And it does say that if there's serious doubt as to the incapacitated person's attitude, they should not infer consent from that. And then we'll hand over to Sarah if she's managed to join us.
I'm here. Sorry, I had some technical difficulties before I joined. So for those of you that were around pre-Cheshire West, like myself, a lot of what I'm going to talk about is very familiar, because effectively what the court's done is gone back to look at all of what we call the Strasbourg jurisprudence and what does that tell us about Article 5, and that's how we've got the test that Sarah Lynn's just outlined. So the point of all of this is that all of our law in this country must stay in line with what the European Court of Human Rights says. There's lots of examples of cases from the European Court within the judgment. So what I've tried to do is focus really clearly on those ones that actually influenced that test and gave us the best idea of why they came to what they came to. So The court reinforced in its judgment that Article 5 protects liberty in its classic sense. So physical liberty of the person doesn't mean we need to concentrate on every interference with autonomy or every restriction on movement. So Sarah Lynn's just outlined the new test, well, the new old test, I would probably say, the objective, the subjective, and the imputable to the state. So we get this from the case of Stork versus Germany. The objective is that confinement in a particular restricted space for a material period of time. Now, what you might remember from Cheshire West is that we used to talk about a non-negligible period of time. But the case that we are talking about now is Stork. That's what the court is saying, you know, we follow, and that's the Strasbourg jurisprudence that we have, and that's the material period of time. Subjective, the absence of valid consent, as Sarah Lynn's outlined before. What we mean by valid consent has definitely changed since we've got this judgment, and imputable to the state, which remains the same. So what happened in Stork? So the applicant in that case was held in a locked psychiatric clinic, forcibly medicated, so sedated, given psychiatric medication against their will, and they would try to escape. When they did escape, they were returned by the police and could not maintain regular social contact. And the key to that case was that she tried to flee and therefore did not give consent and was not willing to stay. And the Supreme Court uses this case and others to emphasize that a person is deprived of their liberty only if they do not validly consent to that confinement. What we don't have is a single acid test. Obviously, we've outlined that, but the assessment, you know, any of these cases must start with the person's concrete and specific situation. Sarah Lynn's outlined really helpfully, I think, a whole range of factors that we need to consider when we are trying to establish what that concrete and specific situation is. So nature, duration, effects, and manner of that implementation. And this multifactorial assessment that we've talked about comes from the case of Gazzardi versus Italy. Now, as you can imagine, we've done a lot of research and we've watched lots of things to be able to get to grips with this judgment. And one of the things that I've seen was some counsel that were involved in this case who referred to that multifactorial assessment as the Gazzardi basket. So all of these things go into a basket, and that's how we decide whether somebody is deprived of their liberty. So what did Gazzardi say? There was a difference between a deprivation of liberty and a restriction of liberty. And what we talk about there is the degree or intensity. And that's what Sarah Lynn just outlined in terms of the impact of the restrictions, the duration of the restrictions, what that relative normality looks like. I really like the case of Gazzardi, and I actually did quite a bit of research over the weekend of where he was sent. So Gazzardi was a suspected mafioso who was sent to a very small island off the coast of Sardinia. And you can visit this very small island on a boat trip, which is very nice. He was forced to live under strict police supervision and cut off from complete ordinary life. And the idea of sending all these really bad prisoners to this island was because they didn't want them to talk to each other in prison, and they didn't want them to continue what they were doing in the mafia. So his restrictions included reporting to authorities twice daily, observing a curfew, needing permission to use the telephone or leave this very small area on this very small island, constant supervision, and being able to only associate with a small group of similarly restricted people. So the degree and intensity of those restrictions were such, and the impact on him was such, that it meant he was deprived of his liberty. Another case that the Supreme Court talked about was Stanov versus Bulgaria. And this was what we were talking about, what Sarah Lynn was talking about in the new test, was about lack of legal capacity does not automatically mean lack of valid consent. So in that case, Mr. Stanov was placed in a secure home by his guardian. He was under constant supervision, needed permission to leave, and was there long enough to feel the adverse effects of the restrictions. So the impact on him was such that it was a deprivation of liberty. He wasn't consulted, though, even though he could give an opinion on whether he wanted to be there or whether he didn't. If he hadn't been consulted, what they would have known was that he wanted to leave. If he went out, he failed to return, and he told people that he didn't want to be there. Mr. Stanov didn't have capacity to make decisions about his care and support, whether he needed the restrictions, whether he needed to be there. But what the court said was he understood his situation, and did he object? If he hadn't objected, he could have given valid consent, because he was such to be able to express an opinion about where he was and the restrictions that were on him. So the Supreme Court in Riagni, which is what we're now talking about, quotes the point that the lack of that legal capacity doesn't necessarily mean that a person is unable to comprehend the situation and consent. Most importantly, so this is what the Supreme Court took from that Strasbourg jurisprudence, that the protective measures should respect the wishes of the people who can express them. So as advocates, you go out all the time and you speak to people, you obtain their wishes and feelings. And actually what we're saying is there are people that can understand their situation, express those wishes and feelings, and actually agree to those restrictions and the care and support that they're receiving. And the cases above were central to the judgment, because the statutory definition of what a deprivation of liberty is tied directly to Article 5. The meaning of a dol has to be governed by these cases, and it's this jurisprudence that rejected the idea of Cheshire West and the acid test. The court went further and said, actually, Strasbourg has always required that we look at this multifactorial assessment of the person's concrete situation, and there isn't a simple formula that we can apply. The court stated that Cheshire West went too far, and the court saw it as their responsibility in this case to bring the law in this country back in line with all of that jurisprudence that I've just explained.
Thank you, Sarah. And I think it's right to say that the court brought it back in line. There is a question about whether it's brought it a little bit too far in the other direction, and there's probably some test cases still to come about that. We're going to move on to talk about what safeguards remain, because this case from the Supreme Court hasn't wandered us into no law. It hasn't wandered us into no safeguards at all. Of course, there are great concerns, and I share some of those concerns about safeguarding and scrutiny and things like that. But we want to talk about what safeguards there are still in place. And so from a starting point, the Mental Capacity Act principles still remain. There is still a presumption of capacity. You still can't make decisions for someone who's got capacity. Decisions for someone must be in their best interests, all of those things. So there still needs to be an assessment where there's a dispute about capacity. The COP can determine that. Where there's a dispute about best interests, the Court of Protection can determine that. Wishes and feelings weigh heavily, and you might say more heavily now that we have this concept of valid consent to a deprivation of liberty. There's a bit of a weird juxtaposition in my mind, which is that a person can't, so they lack capacity to make decisions about their care and their residence. And so a best interest decision is made about that then amounts to a dole, but they can validly consent to that. So that's a really new concept to me, and I imagine to all of you as well. What hasn't changed is the need to authorise a deprivation of liberty. Of course, the definition of a deprivation of liberty has changed. There are people who were deprived of their liberty a week ago who are not now, because their situation on the ground hasn't changed, but the definition of a dole has. However, those that still are still need to be authorised, and that is either by the dole's framework under Schedule A1 of the Mental Capacity Act, or by the Court of Protection in other circumstances. In order to scrutinise those arrangements, we still have Section 21A, so where people are deprived of their liberty and they don't validly consent, there is still the mechanism of bringing that to the court for a review of qualifying requirements. So that's the capacity requirement, mental health, best interests, etc. We still have Section 16 proceedings, that's where the Court of Protection is looking at cases outside of a standard authorisation, disputes about care, residence, contact, social media. I have a couple of cases where I think, oh, this person probably isn't now deprived of their liberty, but it has to remain in court because there are questions about their capacity. There is a dispute in one of them about the care package and the residence arrangements. There's a dispute in another one about whether she's got capacity in relation to sex and marriage and all kinds of things. And so those cases don't suddenly fall away. In terms of legal aid, you get non-means tested legal aid where you are subject to a deprivation of liberty in a care home, and it's a section 21A. So there may be people who are no longer eligible for non-means tested legal aid. What we would do in those circumstances is means test them, and a lot of people still fall within legal aid on a means test. Some don't, and that I think we need to know more about what the legal aid agency is going to do. What else still remains? We're still signed up to the European Convention on Human Rights. And this judgment of the Supreme Court goes to great lengths to talk about actually dolls isn't the only safeguard. It talks about at paragraph 140 and around there, Article 2, which is the right to life, the Article 3, prohibition of torture, inhuman or degrading treatment. So that's where a care package falls under usually the inhuman and degrading treatment rather than the torture. Right to liberty, it still exists. It's just a narrower definition. Article 8 is going to be, I think, quite a big deal, looking at the right to respect for private and family life. And the court actually relied on that a little bit at one point in the judgment to say, all of these assessments that people are having to look at a deprivation of liberty are so intrusive, they could be a breach of someone's right to a private life, you know, where someone's living with their family. So all of this still exists within the umbrella of the Mental Capacity Act and the ECHR. And Sarah Lynn's going to talk a bit about other safeguards outside of the Mental Capacity Act.
Yeah, because it's important to think about in the context of the wider framework.
Sarah Lynn, I don't know about everyone else, but I'm struggling to hear you.
Is that better? I think I maybe knocked
yes.
my headset when I was having a cup of tea. It's important to think about the wider framework of the legislation, because nothing we are doing is ever just looking at purely one section of the Mental Capacity Act. So there's safeguards in other parts of the law as well. One of the big things to bear in mind is that Care Act advocacy remains completely unchanged. So there's still going to be a right to have an advocate attend for assessments, support plans and reviews. And that's going to be a really important tool for identifying and checking whether this test is being properly applied. There's also the Care Act safeguarding provisions, which continue to apply, and it may well be that they are a mechanism by which issues can be brought to the local authority's attention, because the care and support statutory guidance actually says that a potential unlawful deprivation of liberty can be a safeguarding issue. So again, that's one of the mechanisms where we might be able to say to a local authority, look, we're not sure about this. There's also advocacy that aligns with CHC decision making as well, both in terms of the assessments. That's continuing healthcare, by the way. Sorry, just for anybody that wasn't clear. The ICB still has to involve advocacy for the purposes of assessments and also for the purposes of sorting out support plans and making decisions about where somebody's going to live and what care they're going to get. The IMCA role remains. If the local authority or the ICB are looking at provision of accommodation or serious medical treatment for somebody who doesn't have capacity to make that decision, they have to instruct an IMCA. So again, there's another way that we're going to be able to have a bit of an independent check and balance on this system. And the other mechanisms for challenge also remain unaffected, in addition to the Court of Protection. We're still going to have the formal complaints procedures that apply that you can complain to the care home, you can complain to the local authority, and you can ultimately take it to the Ombudsman. So if there is an issue I think what we have at the moment is a tendency to kind of put everything within the Section 21A proceedings because it's standard authorisations. Let's deal with it all under that. And what we might need to do is just find different routes to achieve the same aim. And the Ombudsman may well be one of them. The availability of judicial review remains unaffected as well. So if there is an issue that's not related to best interests, but an issue about whether a care plan is meeting needs, etc., then the judicial review route would be the way to go. What we don't anticipate, and it's a educated guess at this point, but it would seem likely that if the local authority is saying there isn't a deprivation of liberty, and we on behalf of the person think there is, we're probably not going to be using judicial review. It seems likely that the Court of Protection is going to continue to be the arbiter of that point, but the judicial review remains for the more general, whether it's meeting needs rather than best interests issues. And also the CQC are going to continue to have monitoring requirements and responsibilities. They still have to be going in as part of their inspections, and they do check things like the record keeping. And at the moment, they've been looking at things like whether DOLS authorisations are in place where they should be. So we would hope that may well provide another element of an independent check or balance. So there are it's still quite a good safety net. We've only lost one strand of it, but the rest of the safety net does still remain.
So we've all had a nice simple test that we've been very familiar with over the last 12 years, and I think we've definitely got a period of uncertainty before us now as we come to grips with the judgment and try to work out how it's going to be implemented in our individual cases. So we've come up with a list of things that we just don't know the answer to as yet, and I'm sure you've all thought of many other things, and maybe even some of those kind of questions are being put in the chat as we speak. The first one I thought I'd look at is the English guidance. We're definitely going to need some guidance from the Department of Health as to what this actually means in practice and how it's going to be implemented. But how quickly is that going to be produced and what it's going to look like? I don't know. We're just going to have to wait and see. It may be that because Northern Ireland are sort of a step or two ahead of us because they've already got their draft code and some guidance, that the guidance issued in England will be similar to the provisions that they have already come up with. The local authorities and ICBs are going to have to look at their processes and will have to be reviewing their cases. But again, how will they do that and how quickly will they do it? Are we going to be in a position where we're going to have a postcode lottery depending on which part of the country you live in and how quickly your local authority takes action? What will their criteria be? Are they going to be looking at the people who are objecting first, or will they go into individual care homes and look at everybody within that care home before moving on to the next one? I think we're definitely going to need some new DOLS forms so that the forms and processes match the judgment itself. And there's going to have to be new training for best interest assessors and for commissioners as well. For us as solicitors, I think we're likely to be facing arguments in existing COP proceedings about whether P actually is objecting or consenting to the deprivation of liberty and whether any ongoing Section 21A challenges remain appropriate. As for cases for people who are already subject to a DOLS authorisation or where their deprivation of liberty has already been authorised by the court, we're going to have to see whether they will be reviewed formally or just be allowed to lapse. Obviously, they can, at present, they'll only be given for up to a maximum of 12 months, and we'll just have to see how that is got to grips with. And if they are going to be reviewed, who's going to review them? Is it going to be the statutory bodies or Rule 1.2 reps who are going to bring these cases back to court? Or is it going to be the court themselves who are going to request reviews of these cases? I think there's definitely going to be an increase in Part 8 reviews. I think people are probably going to want some clarity about whether people in the care homes are actually now subject to a deprivation of liberty or not. So is it going to be the care homes themselves who are going to issue Part 8 reviews? Or maybe that's a role for you as RPRs to bring those reviews to the local authorities' attention, because then at least there'll be a best interest assessor allocated to look at these, to look at those people's situations and see whether they are now in line with the new judgment. A concern I think that we all have is who is going to be checking whether valid consent is given, and if it is valid and remains valid. Is that going to be up to the care home staff? Is it going to be up to you as visiting advocates? What if people change their mind, and how often will consent be reviewed? They could change their mind from 1 week to the next, as we know many people actually do. Will staff actually be, who are checking this, will they be able to tell the difference between somebody who's expressing genuine happiness with their situation as opposed to somebody who's just passively going along with things? I think we've all had cases where P says, doesn't actually express an objection to the care home staff, but when you go in to see them, they'll be very vocal that there's something they're not happy with. They may not tell the social worker, but they'll tell us, for instance, if they're objecting to being in their placement or want to leave. We've also had cases where staff will tell us, oh, they're very settled, everything's fine, they're not raising an objection. And yet when we obtain and review those records, we can see actually it's a very different picture and people are frequently objecting. So I think this is something which is going to need to have very careful scrutiny. But is any
Nicola, I'm just going to jump in and give you a very quick time call because we're coming up to 45 minutes.
No problem at all.
Cheers.
So who's going to provide that external scrutiny? Sarah Lynn mentioned the CQC earlier, and it may be that they are going to take on that role, and you and as advocates, I think, can certainly play a part there. In terms of interpretation of concepts, I remember the time pre-Cheshire West when we had lots of cases considering whether something was a restriction or a deprivation, and I think we're going to now see lots more cases about how to interpret things like valid consent, what an ordinary life looks like, what situation of relative normality is, and also how long is a significant period as opposed to a not negligible period of time. We don't know whether 16 and 17-year-olds are going to be treated any differently. They don't fall within the current standard authorisation regime. I've actually got a case that's going to court in a couple of days for a 17-year-old who's going to turn 18 soon, and I don't know whether the judge is going to treat him any differently now, because if he's 18, he certainly wouldn't be objecting and is in a situation of relative normality. So we'll just have to see how the court treat these cases. And in terms of legal aid, the legal aid agency may decide to ask us as solicitors for a review of our current legal aid certificates to see if people are still eligible for non-means tested certificates. Personally, I think, though, that it's going to take them quite a while to get their head around this, and it's going to be likely a few months before they take on board the judgment and any guidance that's issued. So there's still lots of things that we don't know, but I'm sure we'll get to grips with it as the months go on, and we'll be delivering more training sessions when we do have those answers.
So I've got a couple more slides to get through. If you do have questions, there's a Q&A. Please put them in there. I've just had a look at the questions, and I'm going to attempt to deal with a couple of concerns that are arising within this. We don't know the answer to some of it because we're waiting. Now, where's the scrutiny? That's the big question for me. Actually, the theory of the new definition is less problematic to me than the practice, because it all depends on who's scrutinising. Paragraph 16 of the Supreme Court judgment said all of this. Now, I'm not going to read it out, but it said that the administrative arrangements needed to change around the DOL scheme. And that's, Nicola said, you know, we're going to need some new DOLS forms. The court was assured that where valid consent is given, it would be subject to review, and as a minimum, there would be a formal review once a year. A change in the individual's wishes and feelings regarding their confinement would constitute a change of their circumstances, requiring review of whether they are in fact continuing to give that valid consent, and whether authorization was required. If consent can't be demonstrated at any given time, those responsible for the confinement are at risk of both civil and criminal liability. So, you know, the care home could be unlawfully depriving someone of their liberty. The court made this decision based on lots of things, but one of those things was this reassurance that there would be a formal review of those wishes and feelings. It doesn't say who's reviewing. It also says at paragraph 20 that the Attorney General for Northern Ireland submitted that safeguards would focus on identifying wishes and feelings. And so in order to make sure that any arrangements were compliant with Article 5. And so the Supreme Court has made this decision based on there being a mechanism for ongoing review, but we don't know what that is yet. ADAS, Association for Directors of Adult Social Services, issued some comment on Friday, which, among other things, said there needs to be a period of reflection, and they believe that work on cases which are in the system can just be paused, not while guidance is developed and agreed. So if you are facing a local authority just flinging things through, going, that's not at all, that's not at all, that's not at all, you can point them towards this response that says that a cautious approach is recommended, and that they should wait for guidance from the Department of Health and Social Care and have a time of reflection before producing operational guidance. And so what all of this says is that ADAS certainly isn't saying you should just strip all of these cases out and say they're not at all. And there isn't any English guidance yet. My question is, how will that guidance ensure there is some scrutiny? Will the new processes build in a formal review of valid consent? Because there's a question in the chat about about external scrutiny and all of those concerns that did arise in the liberty protection safeguards about care homes marking their own homework. They're back. They are, I don't deny it, they are absolutely back. But before we panic, let's wait and see what this guidance is going to say. If there isn't a process for formal review, is that process going to be in line with what the Supreme Court said at paragraph 16, reliance on the fact that there needs to be that scrutiny? And so it's a big question going forward. Sarah's just going to give us all a little plug, and then I'm going to come to the questions. So if you've got anything burning, please put it in there now and we'll try and deal with it.
Yeah, and there was a few questions in the chat box that I've transferred onto the Q&A, so we can try and keep them together. I thought it might be helpful. So obviously, this is a very important change in the law. It has an impact on all of us and all of the people that we seek to protect and represent. And we know that there's a need for us to continue the conversations that we have. Just a few of the questions that have come in. You know, there's huge things that have changed, huge things that we don't know, and huge things that we need to be able to support you on. And what we want to be able to do throughout this, and when we work with you, is to provide that sensible, proactive advice to help you do your job. So what are the things that we can do to help you do that? So for those of you that don't know, we host a monthly drop-in. If that is something that you don't attend or would like to stay on the mailing list, want to continue to attend, please provide your email address within the chat box if you want to make sure that you're subscribed. We have sessions covering a broad range of topics, guest speakers, practical hints, and the opportunity to ask questions about cases that you've got, or just general themes. Now, obviously, that's going to be something, you know, any new cases arising out of this, any new guidance, we're going to keep that completely up to date within that monthly drop-in. If you're watching this on record, or if you don't want to share your email address in the chat, we've added our events email address there, and that will make sure that you can be subscribed. In terms of new enquiries, please contact our new inquiries inbox. Where you know a member of the team and you've got our emails, please feel free to continue to contact us directly and all of that. But if you don't, or there's something that you don't need it to be someone specific or whatever it might be, then please use that inbox that is dealt with by the whole team, and your inquiry will be directed to the office that is kind of closest to you and is more appropriate to deal with that inquiry. Training sessions. I know we've already had lots of discussions with lots of your organisations about bespoke training on this issue and other generalised issues. If you're not already liaising with us and a training session on this area or anything else might be useful for you, then I've popped my email address there so that I will, liaise with marketing and make sure that again goes to the right office, who will deliver some free training to your organisations to make sure you're completely up to date about the judgment and about other things as time goes on. We're a really friendly bunch. I think it's worth knowing that, lots of you that work with us. Hopefully you know that we are only ever a phone call away. So feel free to contact us at any time, even if it's like, I think I know the answer to this, but I'm not sure. What we will see probably in the forthcoming weeks, months, whatever, is local authorities will take a stance and they might come to you and say, what's your view on it? And it's those things that you should absolutely feel free to contact us and say, this is what they're saying. I think that's right, but can you sense check it for me? Can you, give us some reassurance? So whatever it might be, feel free to get in touch with us.
Thanks. And after that shameless plug, I am going to address the questions that we've got. We haven't got loads, but they are some important ones. If you've got any more, now's your time. I'm going to deal with the last one first because I can deal with it very quickly, which says, is essentially, are Section 21A proceedings still going to be subject to non-means tested legal aid? Yes. Section 21A still attracts non-means tested legal aid. I was talking before about Section 16 proceedings, which is where there's not a standard authorisation in place. That is still means tested. Section 21A still attracts non-means tested legal aid. There is a point where fewer people will be subject to a deprivation of liberty, so fewer people will have a standard authorisation, and so fewer people might get that. However, it's worth bearing in mind that those that are objecting who would bring a Section 21A are not giving valid consent, so they will mostly still be within the definition of a deprivation of liberty. So, other questions. How does this impact current RPR, Rule 1.2 and IMCA cases? Sarah Lynn, Nicola, does anyone want to take it?
I can pick up some of this and maybe some people can jump in. I think that the role that is going to be a bit clearer or is the easiest to answer in this is the Rule 1.2, because what we find in a lot of our Rule 1.2 cases, they are streamlined cases where the person is not objecting. Everybody's happy to with the care and support, and effectively they are going through the COP Doll 11 process. I think in reality what we are going to see is that COP Doll 11 process not continuing, because by virtue of their not objecting, and obviously that will need to be considered, in terms of their acquiescence, in terms of sedation, in terms of all of that. But if somebody is genuinely happy in a relatively normal, situation, everybody's happy with the care and support that's being provided, then actually what are we serving? They're not going to be deprived of their liberty. And if they do meet subjective, they're not going to meet the objective, no, the way around. They're going to be able to provide that valid consent. And therefore that Rule 1.2 element is going to change. Now, what I will say is you get involved in these cases and you determine whether you are happy with that care and support. So if somebody is determined that they have restrictions on them and they come to you as an advocate and say, are you happy with these restrictions? You would be able to know whether somebody is objecting, and therefore they wouldn't be able to validly consent, and therefore it would still be a case because you'd look at the care and support plan and something's not right, they need to move. you know, the family, the way in which the care is being provided is incorrect. So I think in terms of that element of it, that's going to be the biggest change. In terms of your RPR stuff, then it's going to be a case of determining how the local authority and care homes and all of these people are going to determine whether somebody can give valid consent to their arrangements. What scrutiny, as Eilish and everyone's talked about, what scrutiny they are going to provide. Will you be asked to look at whether you agree with that assessment on valid consent? One of the things that I've heard being talked about is it's a lot to place on one person. And I know also we've had a comment in the chat about we're going back to relying on care homes who are notoriously bad at picking up objections or even thinking that somebody is an objection. So in terms of the RPR role, it is going to develop, but we just don't know how it's going to develop yet. And I think one of the most important things to say is don't panic. You know, everybody's saying everybody's going to do things slightly different, but we need to take our time with it. We need to make sure we are making decisions on individual basis rather than going, all of those people aren't deprived anymore, or all of these people aren't.
Mm-hmm. And then in terms of RPR cases where someone is subject to a deprivation of liberty in a care home, that remains, they still have an RPR. IMCA cases are going to be even more important than ever, because where I'm kind of trying to address, there is now quite a few questions. We don't have loads of time. We're quite happy to go a little bit over, but we don't want to go loads over time. IMCA cases are going to be more important than ever. They are applicable where someone is having a long-term change of residence. And at that point, it's important that an IMCA is getting involved and saying, no, they are objecting. And so they are going to be more important than ever. And so is Care Act advocacy, to my mind, because the Care Act requires annual review and it's not always happening. And so actually there needs to be a bit of, I think we've thrown a lot at dolls, which is right, but it's probably time to start looking more at those other safeguards as well. So the Care Act as well. In terms of the new approach, who's responsible? I addressed this a little bit. Who's responsible to decide whether an application can be made? Feels like the concerns regarding LPS and care homes being gatekeepers have returned. I agree. That is a big concern. We need to wait and see what the guidance is going to be. But where there's an advocate involved, you can still bring a challenge, you can still talk to a solicitor, all of those things. Just to address another question while we're talking on this point, often pushback in terms of recognising objections and necessity for a Section 21A from both care facilities and local authorities. Are objections being clearly defined to support P as part of these changes? Will advocates be removed from the people who don't have family or friends to visit them? And if so, who is left with responsibility for checking in with these people? There is a big concern that those people who aren't objecting, who have an RPR, who goes in and checks in with them, and they continue to not object, but you raise a safeguarding concern and all of those things. You check that, you know, they're actually, the conditions are in place. You just help them with, why does their hearing aid just keep going missing and so they can't hear a thing? There is a concern about that. We need to wait and see what the arrangements are going to be. This has been a bombshell in the middle of what we all do, and so we don't know yet is the answer. There is other types of advocacy that we do think are going to become more important. Yes, we can share the slides and a recording. That's an easy question. How does the liberty protection safeguards legislation fit in? Might new legislation be needed since the LPS is predicated on Cheshire West? Who wants to take that?
I don't mind weighing in. LPS was a bit of a research hobby of mine for quite a long time. We were actually just discussing this in our preparation before this session, because LPS itself generally is a bit of an unknown at the moment. There is ongoing consultation at the moment. I think the consultation window is still open, so it's very likely that we're going to see some changes. I don't necessarily think the legislation itself is going to change. I think the new test will slot in quite easily. I think what we're likely to see is the code of practice, which is what the ongoing consultations and things at the moment are about, will factor in this new test and hopefully provide us with if LPS ever comes in, because who knows, but if it does, then we might have a more unified framework for community versus residential care. And all that's changing really is the definition of deprivation of liberty. The LPS as a whole, if they choose to implement it, will still be implementable. I think there was some attempt to more firmly define a deprivation of liberty within that schedule. So we might see that one section change to reflect this, or government might keep the law because the Supreme Court said it's for Parliament to change the law if they want to change the law. I think that's probably unlikely. I think it's more likely that we're going to see this new test incorporated into that code of practice and the regulations and things that will accompany it should the LPS ultimately get implemented at some point.
Thank you, Sarah Lynn. If you haven't put a question in the chat, I'm just going to deal with what's in there now. So anything, because we are a little bit over time. Very quickly deal with where does this leave us with 39A IMCA cases. The rules about that haven't changed. And so if someone is deprived of their liberty and have an RPR who's a family member, unpaid RPR, they still have the right to have that service as a 39A IMCA. However, fewer people are going to be deprived of their liberty, so have that standard authorization, so have the RPR, so need the 39A. But the actual route to getting one is the same. Someone's asking, I have a Rule 1.2 case, cases which are due renewal. What do I tell my client? I don't know, because I don't know the facts of the case. And I would be remiss to try and answer that. If they are truly happy where they are, then it may not need an authorization. If they are not, then it may still be a deprivation of liberty and may need to go to court. You're welcome to contact us if you want to actually discuss those individual cases, but I don't want to start guessing at facts. And then,
Eilish, sorry, Eilish, I was just going to say on that point that in reality, in these cases, the local authority kind of needs to take a view as well. And then that's the ones where you're saying about contacting us and having those discussions as to the alternative view and whether that's agreed or whether there is going to be a dispute and there has to be an argument about whether it is or not.
I think that's right. We've got a case where, because we've got a big property and affairs department, and where one of the property and affairs deputy is rarely, but is a welfare deputy for one of our clients, and the ICB was in the process of renewing the DOL, making the new COP DOL 11 application, and has last week said, oh, we now don't think we need to do this. I think they need to provide some evidence as to what they've done to ascertain wishes and feelings. And they haven't done that yet. So last question, let's go with an easy one. If a client is in a care home and consents to be in there, meaning a DOLS is now lifted, does this mean the person is free to leave?
I can do that one as well if you want.
Yep.
In reality, the DOLs will only be lifted if they are consenting to every restriction that is on them. And one of those restrictions is that they wouldn't be allowed to leave, presumably. So in reality, valid consent is only a valid consent to whatever the restrictions are in that care plan and whatever the restrictions are in the care home. So if one of their restrictions is that door is locked and they are not allowed to leave, they need to consent to that element of their care plan. And so they're not free to leave. They are just agreeing that they won't.
Yeah, and I'm just rifling through my very scrawled judgment to find paragraph 154, which talked about the case of HL, which is known as Bournewood, and like talking about Bournewood makes me feel like I'm at university, and the Bournewood gap, and that this is what prompted Schedule A1, because it was found that there was a gap in our law for people who were not objecting but kind of not sectioned but didn't have capacity. And what it talked about in the description of that case was, since the power of compulsory detention was kept in mind by the authorities throughout as an option to be used immediately if HL ever showed signs of wanting to leave, it is unsurprising that the court regarded compulsory detention as the relevant analogy rather than voluntary acceptance of his situation. Anyone who does IMHA work and deals with people who are sectioned under the Mental Health Act will have come across people who are voluntary or informal, as I would prefer to call them, because it really annoys me, because as soon as they say, well, actually, I don't want to be here, they'll be sectioned. And that's probably analogous to the situation here. It's opened a really difficult gate there. But as Sarah says, they're not saying, essentially, if they start to say, well, I want to leave, that's no longer valid consent. So it becomes a dull. What a weird situation that is. We're going to wrap it up. Thank you all so much for coming. There's one further question that says, what's a realistic time frame for new tests and framework? I don't know the answer to that, I'm afraid. Yeah, I couldn't possibly try and guess. And so I apologise that I'm going to leave it at that. You know where to find us. Thank you all for coming. If you do want to be signed up for the drop-in, we do it monthly. We have a different topic every month. This will probably feature heavily, and have a lovely day.
Yep. Thanks, everybody.
Thanks,
Bye.
everybody. Bye.
Thank you all. Bye.